I'm Blake Mahoney, and this is my presentation on the interpretation and understanding of 303 Creative LLC versus Lanus by local business owners. In the United States of America, there are certain rights that all citizens are promised. However, the application of these rights is constantly up for debate. For decades now, a war between religious rights groups and LGBT rights groups has been waged throughout the American legal system. LGBT groups want the right to fully participate in the free market, while religious rights advocates want the right to refuse service when they believe their beliefs are contradicted. The most recent example of this battle is the 2023 Supreme Court case 303 Creative LLC versus Lanus. In this case, the owner of a Colorado-based graphic design business, Lori Smith, wished to expand her services to include the creation of wedding websites. However, Smith wished to post a statement on her website that she would not create websites for same-sex couples. She believed that by creating a website for a same-sex wedding, she would be expressing views contradictory to her religious beliefs. Smith feared, however, that the Colorado Anti-Discrimination Act would not allow her to do so. CADA is a law in Colorado that outlaws discrimination in public places based on race, religion, and sexual orientation. Her response to this fear was to sue the state of Colorado, claiming that CADA violated her First Amendment rights. The case made its way through the court system all the way up to the Supreme Court. When it reached the Supreme Court, they ruled 6-3 in favor of Lori Smith and 303 Creative LLC. In their ruling, they stated that by forcing Smith to express views that were contrary to her own, CADA violated her First Amendment rights. The 6 judges who ruled in the majority stated that Smith's refusal to serve same-sex couples was not discrimination, but just a preservation of her constitutional rights. So what does the ruling actually do? It doesn't, as some may believe, strike down anti-discrimination laws. The Colorado Anti-Discrimination Act challenged in this case is actually still standing. In fact, the majority opinion specifically stated that anti-discrimination and public accommodations laws are not inherently unconstitutional, but that forcing businesses to create art that contradicts their values is. The court classified a wedding website as a form of art because they believed that it would be Smith's own views expressed through the creation of that website. However, the court declined to define what qualifies as expressive activity protected by the First Amendment. This leaves the question of which services and goods exactly are allowed to be denied to people due to their sexual orientation. Due to the fact that this case is so recent and that the ruling itself is fairly vague, how exactly this decision will affect same-sex couples in the marketplace is still unknown. In my research, I hope to answer the question of how local business owners understand and interpret the 303 Creative case, and if it is affecting the way that they operate their businesses. Will this ruling be used as a way for business owners to act on prejudices and exclude LGBT people from their business, or will it truly only be used to protect the religious freedom of expressive business owners? There is such a scarce amount of research into this case because of how new it is. Pretty much all the existing research is exclusively looking into the background and facts of the case, not its application. Understanding the effects this case will have on local economies and business practices is extremely important, even for people who don't identify as LGBT. If the case is being improperly used as a blank check to discriminate against people whose lifestyle a business owner doesn't agree with, then legislation needs to be passed to ensure that consumer rights are being protected. Martin Luther King famously stated that injustice anywhere is a threat to justice everywhere. If we turn a blind eye to discrimination in our local communities, we are allowing injustice to take root. By shining light on the ways that this case will be used, I hope to ward off that potential discrimination and injustice. I predict that through this research, we will come to discover that most local business owners are unaware of the case. Those who are may not fully understand its implications and whether or not it even applies to them. The best way to figure out how this ruling will be applied is to talk to those who will essentially be the ones carrying out the case, business owners. Here, I will talk to business owners to try and understand their views on the case, what they think the case allows them to do as business owners, and whether they plan to change any of their business practices as a result. When analyzing the effects of the 303 Creative case, one must ask to what extent expressive businesses are allowed to refuse service, and to whom they are allowed to refuse service to. A 2023 essay looked into how the court's reasoning and decision in the case would affect whom businesses could actually refuse service to and why. This paper points out how the court distinguishes objecting to serving same-sex couples from objecting to serving members of racial civil rights groups. The attorney arguing Smith's side of the case pointed out how in the case of Obergefell v. Hodges 2016, the court described people who oppose same-sex marriage as reasonable and sincere people, and that their biases are based on honorable religious and philosophical premises. The court distinguishes this from individuals who discriminate against racial groups because their motivation in doing so is not justifiable. When Justice Samuel Alito asked the attorney whether it would be honorable to discriminate based on race, she said that it would not. This article found that the court's ruling in this case did not affect earlier precedents that rejected First Amendment protections granted to business owners who were bigoted against certain racial groups, and therefore contained the effects of the case to not apply to any racial civil rights groups. Even though the outcome of this case does still leave civil rights protections in place for racial groups, it does appear to open the door to some level of discrimination. Another 2023 research paper argues that Lori Smith essentially used selective commercial service to discriminate under the guise of religious expression. The paper makes a point of setting this case apart from recent cases concerning religious expression and LGBT rights, as she not only wished to not have to serve same-sex customers, but also wanted to be able to preemptively display a message saying that she would not serve them. The author argues that Smith is not simply abstaining from serving customers that she does not agree with, but proactively using market discrimination to exclude those people from her corner of the marketplace. By making the decision that they did, the court seemed to set the precedent that the expressive freedom of a service provider trumps the right of LGBT people to fully participate in the marketplace. 303 Creative is not the first case of its kind to appear before the Supreme Court. Back in 2018, the court heard the case of Masterpiece Cake Shop versus Colorado Civil Rights Commission. This case is very similar to 303 in that they both deal with a Colorado business owner who wished to refuse service to a same-sex couple. In Masterpiece, the court ruled in the favor of the business owner, but it did so on the ground that the Colorado Civil Rights Commission showed unfair prejudice toward him. This case and its effects are discussed in a 2018 article, which argues that because the ruling was based on the treatment of the business owner by the commission, it didn't actually provide exemption from anti-discrimination laws. The ruling only applied to this specific case because it concerned specific comments made by the commission that the court deemed hostile. The author notes that without those particular facts, a different case could lead to a different result. 303 Creative is that different case. Due to the fact that it deals with the actual legality of refusing service to certain customers and not with the actions of the Colorado Civil Rights Commission, 303 has actual concrete effects for not only this specific case, but for all Americans. The primary method I use to collect my data is semi-structured interviews. This method is ideal for my research because I do want hard answers to certain questions, but I would also be able to use unscripted questions to probe deeper into the business owner's understandings and opinions of the 303 Creative case. This method allowed me to get the clearest, most complete picture of how the case is being interpreted and applied by local business owners. As a 2022 legal research article stated, semi-structured interviews have the advantage of following a broad protocol and the flexibility of following new lines of inquiry based on the responses of interviewees. If I were to go with the structured interview format, I would be able to get the answers to the main questions I want to ask, but I would not be able to know their reasoning behind their specific answers or go deeper into their viewpoints. I could have done a survey, but that would have made it easier for the subjects to give inaccurate answers and more likely that they wouldn't provide an adequate amount of information. The first step of my research project was recruiting subjects. I did this by reaching out to business owners through email, explaining my study and what their level of involvement would be. I obtained 3 business owners as subjects, not concentrated in a single industry or business type. I studied both businesses commonly identified as expressive and those that are not commonly seen as such. Once I selected my subjects, I arranged interviews with each of the business owners separately. In these interviews, I started by asking my pre-structured questions. These questions gave me an idea of how familiar with the case the subject is and whether or not they plan to change their business practices due to the ruling. I started by asking them if they had heard of the case, if they were unfamiliar with the case, or if they'd heard of the case. If they were unfamiliar with the case, I described it to them and saw if they were familiar with either the case or the general concept based on the description. I then asked them how they interpret the ruling of the case, what rights they believe it grants them, and if they have exercised or would exercise these perceived rights. Since the case specifies that the ruling only applies to expressive businesses, I asked them if they considered their business an expressive business. Finally, I asked the subject whether or not they believe religious beliefs should play a role in business ownership, and whether or not it plays a role in how they run their own business. Throughout the process, I also asked follow-up questions to push deeper into their answers to these planned questions. In order to analyze the data from my interviews, I used a thematic deductive coding method. All the subjects' answers to the questions were recorded on paper, and I combed back through their answers and used deductive coding in order to analyze them. I looked for patterns in understanding, interpretation, and application across the subjects. These patterns were used to determine trends in how the 303 case is affecting local businesses, their owners, and their customers. The 3 business owners I ended up interviewing included a bakery owner, a restaurant owner, and a retail shoe store owner. I started off the interviews by asking the subjects if they were familiar with the Supreme Court case 303 Creative LLC versus Salinas, which occurred in the summer of 2023. Based on just this information, none of the subjects had heard of or were familiar with the case. I then proceeded to explain the facts of the case to them. After this description, all the subjects claimed that the case sounded familiar to them. The baker owner elaborated, saying that she was aware of cases that dealt with similar issues to 303 Creative and knew that the court generally ruled in favor of religious rights in these cases, which is a correct observation. The next question that the subjects were asked was what rights they believed this case granted to them. The bakery owner said that she believed it gave her the right to refuse clients who request her to produce a product that goes against what she believes in. The restaurant owner stated that the case gave her the right to be discriminatory and refuse service based on race, sexual orientation, religion, or other categories. The shoe store owner believes that the ruling makes it so that he doesn't have to sell to anyone that he doesn't want to. Based on the bakery owner and the restaurant, both the baker owner and the restaurant owner went further, stating that they believed this to be a right that they already had and that the case didn't expand or contract their rights in any way. The subjects were then asked whether or not they considered their business to be an expressive business. The bakery owner said that she did because her business allowed her to be creative in some ways, and she does see her cakes as creative products. But the restaurant owner and the shoe store owner did not view their businesses as expressive. Next, the subjects were asked if they would exercise the rights granted / outlined in this ruling, and if they have exercised these rights previously. The bakery owner stated that she had turned away customers before on the grounds that the messages they requested to be printed on the cakes were phallic, pornographic, or otherwise inappropriate. The restaurant owner didn't firmly say whether or not she would exercise it, but she did say that she could refuse to hold, say, a wedding reception for a sexual orientation group that she doesn't agree with in her restaurant. The shoe store owner said that he couldn't think of scenarios where he would refuse service to anyone, but said that if a situation like that did arise, he would have the right to not sell to them. The subjects were then asked to what extent religion plays a role in how they operate their business. The bakery owner answered that her religion is who she is and that she runs her business with her faith. The restaurant owner stated that her business defines her values and morals, but not how she runs her business. The shoe store owner said that his faith was not a part of how he ran his business, but that other business owners have the right to run their business based on their faith if they want. These interviews paint an interesting picture of how the 303 Creative case is known, interpreted, and applied in different businesses within this community. All the subjects seem to favor interpretations and applications that prioritize their rights as business owners over the rights of consumers. Even though they weren't immediately familiar with the case, they believed that the rights the case affirmed were rights that they already had as business owners. Based on the uniformity of some of the answers, despite the differences in types of business, assumptions about other business owners within the same community can be drawn from the data. The first assumption that can be drawn is that most business owners within the community are probably not familiar with the 303 case itself. However, there's most likely a portion of them that are aware of similar cases and are aware that the Supreme Court tends to rule in their favor. This assumption is based on the fact that none of the subjects were immediately familiar with the 303 case, but were generally familiar with it after the description. The bakery owner had knowledge of similar cases, which is why the assumption that some business owners will have a deeper understanding of the legal battle can be drawn. Another assumption that can be drawn from the data is that local business owners interpret the ruling in this case as affirming, not granting, the rights to refuse service to pretty much anyone they want. All the subjects that I interviewed believed that this was a right that they already had, and that this ruling did not grant or take away any rights to or from them, but instead affirmed rights that they already had. They all believed that this case affirmed their right to refuse service, but each posed different levels of restrictions with their wordings. The bakery owner believed that she could only refuse service to a customer if they requested a product that was inappropriate. This is different from the situation in the case where Lori Smith wanted to preemptively post a message stating what sort of customer she would refuse to do business to. The restaurant owner and the shoe store owner both interpreted broader limitations for themselves. There are a number of clear misinterpretations present here. The first and most clear one is that the restaurant owner and shoe store owner believing that this case grants them the right to discriminate, while also stating that they don't view their businesses as expressive businesses. The majority opinion clearly states that the First Amendment only applies when a business is creating expressive goods or services, which I stated to them while describing this case and the ruling. This is an example of how businesses, even ones that this ruling doesn't technically apply to, may still use the case as justification to refuse service to anyone they want. Surprisingly, the bakery owner, the subject who identified her business as an expressive business, is the subject who put the most limitations on her right to refuse service by saying that she could only do so when a customer requested she produce an inappropriate message or product. The final set of answers helps paint a picture of how the subject's right to refuse service, or their perception of this right, was actually being applied in real life. Both the restaurant owner and the shoe store owner said that they had never had a situation where they felt the need to exercise their right to refuse service, while the bakery owner shared that she had refused to produce cakes with certain messages or images on a variety of occasions. This set of answers is somewhat surprising because the two subjects who have never refused service are the two who gave themselves the widest set of parameters for which they are allowed to do so, while the bakery owner gave herself a narrower set of parameters and yet has the right on numerous occasions. In review, all of the business owners were unfamiliar with the case based on just the name, but were familiar with the general idea of the case once I described it. There was broad misinterpretation of the case from all the subjects, and differing approaches to how subjects believed the ruling should be applied. All the subjects seemed to believe that they had more right to refuse service as business owners than they actually do according to the law. This misunderstanding of rights among business owners could lead to consumers being unjustly discriminated against. To remedy this, the government should do a better job of educating business owners on when and why they are actually allowed to refuse service to customers and how specific court rulings apply to them. The law is a very complicated and fluid thing, and not understanding certain parts of it can lead to unintentional wrongdoing towards others. Here are my works cited.
Thanks, Blake. The panel has a few questions for you, and we'll wrap this up.
Hi, thank you so much. I'm going to ask you a question about your research. How did your initial exploration of the scholarly conversation lead to your final research question or project?
Yeah, so one common theme among all the existing research on the case is that it was all kind of in the background of the case or in the actual process of how the judges were ruling on the case, because this case is so recent. It happened just last summer. So there really was no research into how this case was actually affecting people and being applied. And so obviously there was a huge gap there, so I wanted to look into that and begin to fill that, at least in my own community.
Excuse me, can you go into what some of the real world implications of your research might be?
Yeah, so what we saw in the research is that there's a lot of misunderstanding and misinterpretation of this case. And while it's clearly stated in the majority opinion that it only applies to expressive creative businesses, a lot of business owners, even the ones who don't see their business as expressive, such as a restaurant owner or a retail shoe store owner, are still believe that this case grants them the right to discriminate when the opinion and the ruling clearly states that it doesn't. So I think that the implications here are that this case and how unclear it is could lead to a lot of unjust and technically illegal discrimination.
What was the most important research skill you developed as a result of this process, and how might you apply it to your future endeavors?
So I think that this research project really helped, really taught me how to especially conduct interviews and then use that information from the interviews to kind of synthesize into, results and my final findings. And so I think that the skills that I learned in this research process will help me to, in my future, whether I'm doing research or even if it's just in school and I'm learning, synthesize information from different areas into one cohesive image.